moderator is Professor Martinez, who is a co-director of the Underground Clinic here at the University of Montana. And also going to be Matthew Fletcher, Miguel, and Angela Ryan. Matthew Fletcher is a professor of law at Michigan State University, and he is the director of the Indigenous Law and Policy Center. Symposium Miguel is an associate professor of and director of Indigenous Law and Policy Center at Michigan State University. And Angela Riley is a professor of law teaching intellectual property, federal Indian law, and good neighbor governance at UCLA. She's also the director of the first degree program in law and American Indian Studies and Native Nations Law and Policy. Matthew Fletcher will be speaking about copyrights and the Indian Child Welfare. Angela Riley will be speaking about governance and changing Native Nations in the current era, and Miguel will be talking about Native governments. Thank you.
Introductory remarks, if you want. Sure. Okay. So thank you for the introduction, and special thanks to the Montana Law Review and their staff and leaders and advisor who have worked so hard to put this conference on. It's, I guess incredible is kind of a strong word to use, but to be Indian law faculty at an institution where the Law Review puts on an Indian law conference is quite a luxury, and I really appreciate the commitment, not just that the Law Review, but the institution itself has taken on to Indian law. There are a number of other colleagues, certainly my colleague Maylin Smith, who has been leading the field here at the school for a long time, but colleagues across our faculty have really taken on an interest in the field, and I appreciate all of their help and support for events like this and for Indian law in general. I also want to thank all of our esteemed guests. Professor Fletcher was talking about the Illuminati. I think we kind of have the Illuminati of Indian law here, so that's quite the luxury to be in the company of so many people who have shaped our thinking about Indian law, and really giants in the field. So thank you all for coming. I want to send special thanks to Professor Palmersheim for breaking the F-word barrier this morning. I was a little concerned that our panel would have to do that, particularly since we may spend some time discussing the decision of the district court down in Texas with regard to the Indian Child Welfare Act, but I'm pleased that Professor Palmersheim crossed that Rubicon already. And more importantly, that he had a federal judge for a moderator, and I won't have to take on the same duties. But I did want to touch just briefly in thinking about this particular panel, and perhaps as a way to contextualize it in regard to our day today. Professor Palmersheim mentioned the need for hope, and it was particularly poignant, I think, and hit home for those of us who teach federal Indian law in these times. And I think there is significant reason for hope in the field, and I would offer that much of the reason, at least I see, for hope is the governance and the activities that tribes are carrying on every day in Indian country. As was mentioned, over 570 federally recognized tribes, not to mention, as Professor Fletcher did, members of state-recognized or even unrecognized tribal groups are engaged in making decisions every day that affect the lives of their citizens and are engaging in the hard work of government and subject in many ways to challenges that no other governments face, as you heard this morning, for example, providing due process for their citizens in courts, things that other governments may not even conceive of or long ago sort of made a decision to proceed down a path. And as Professor Riley has written in her previous work, the vast majority of evidence shows that in many cases tribes are actually engaging not just in governance, but in good governance. And particularly in our current times, we could ask for much more good governance, I would think. I'd also like to point out, and both Professor Singo and Professor Fletcher have written quite a bit about the idea of disruption and the role of tribal governments, and particularly tribal governance, in disrupting our ideas of what governance is and how governments can change, and really creating new avenues for thinking about the rights of individual citizens or the exercise of sovereignty. And perhaps in the current time, or certainly there are many disruptions, whether they be, for example, social movements like the Me Too movement or Black Lives Matter or other social movements. There is a lot of disruption going on, and so maybe it is most appropriate for us to look toward tribal governments and native governance for lessons in terms of moving forward. And I think we're going to hear today from our panelists about how we might think about those things. Professor Singo will lead us off talking about the ways in which the Me Too movement is affecting and carrying out native governments and tribal governments. So we'll begin there.
Miigwech. Is it all right if I sit here?
Absolutely.
Okay. Ani Buju, it's such a wonderful honor to be here, and thank you to the Montana Law Review and also to Professor Mills and to the Montana NALSA and to everyone here for welcoming us. So it's thank you so much. My talk is on the topic of the Me Too movement and some thoughts that I have regarding as it applies to Indian country. And I'd like to organize it in a somewhat non-traditional fashion. I'm going to intersperse my presentation with some storytelling. So I hope that that's not too disjointed or confusing for you. So it begins with some thoughts about which I call On Being Young, Female, and an Indian Lawyer in Washington, D.C. And it's based on my own experience graduating law school in 1999 and setting out for my first work in the field of Indian law in Washington, D.C., where I worked for a very large law firm with an Indian law practice. I was very optimistic, one might say naive, but the practice that I worked for did not continue to represent the interests of tribes and work as an advocate for tribal sovereignty as I had hoped. And soon I found myself looking for other opportunities in the D.C. area in the field of Indian law. And some of those experiences certainly stood out for me. One included recommendation that I attend a conference in D.C. of a major regional intertribal organization to meet other attorneys and to network. And I was introduced to the president of the organization, and as I spoke and explained my position and my interest in exploring other opportunities, he asked if I would like to speak with him in his hotel room and continue that discussion, which I felt was highly inappropriate and shocking and surprising to me. Of course, at the time I was, I think, 27 years old. And it was not something that I reported at the time to anyone. This was not someone I worked for, but I definitely felt uncomfortable about it. And there were other experiences in D.C. that I think many others have experienced as well. In the law firm where I worked, I had two other male attorneys share an office, and every single day I received comments about my appearance and about basically their attempt to engage in what they thought was an everyday flirtatious banter, but it certainly was not welcome for a new attorney in an environment where I wanted to be perceived as a professional contributor to our law practice. But in the end, what I want to also address is that this experience of the experience of sexual harassment is something that is very widespread. And I also connect it to this deeper, broader experience of sexual violence within Indian country and the way in which that has become so pervasive. And of course, as you know, based on the massive discussion about the reauthorization of VAWA both now and in 2013, we are well aware of the deeply disturbing statistics that, for example, 56% of all American, Indian, and Alaska Native women have experienced sexual violence in their lifetime, and that 3 out of 5 women in Indian country experience it. But, what I also want to emphasize is that compared to other American women, Native women are 2.5 times more likely to be sexually assaulted. And also, of those, 90% of Native American women who experience sexual violence say that their attackers were non-tribal. In addition to that, we do not have widespread data, comprehensive data about the incidence of sexual harassment per se, but we do know that individuals who work for advocacy organizations such as the National Indigenous Women's Resource Center report that they receive frequent complaints from women regarding sexually explicit comments, examples of women being coerced into sexual encounters, and sex discrimination, and retaliation against those who report or act as whistleblowers related to sexual harassment. So this is certainly an area where we need more information, more data. And so then I want to flip to the second part of my focus here, and that is, I call this part returning home. Soon after working in DC, when I decided to look for other opportunities, based on those incidents, I did decide that I wanted to return home. To my home was Michigan, and I found employment in Michigan. But at the same time, I associate this return home with some greater maturity that I obtained regarding my insight into the cycle of how the cycle of Indian removal and sexual violence and sexual abuse had affected my family and my community. My own mother was taken by Catholic Social Services with several of her other siblings and placed into foster care as an infant. She was later adopted along with a sibling. And the family that adopted her, they were a non-Indian couple, as is so common with children who are adopted. And they later, after the adoption of my mother and my aunt, had other children, 3 other children who are not Native. And while those other children see their father as a saint, as kind and gentle, my mother came to see this father as someone who was sexually abusive, somebody who was very harmful and very frightening. And this is a phenomenon, unfortunately, that we see of victimization of children, so common in our communities. And this is deeply disturbing as well because this experience of children being removed from their families, of children being harmed by those families that adopted them, is something that has been experienced not just in my own family, but it's been experienced in multiple generations of my own family. And it's also been experienced in other families of my aunts and uncles as well. And so this also leads me to think about what it means to return home and what I was hoping for and what I would have liked to have seen. I would, of course, like to have seen a community that could care for itself, a community that offered protections against sexual abuse, against any harm to children and to adults. And yet I came back to a context in which we were no longer part of our tribal community at that time. My tribe had illegally been deprived of its federal recognition by a series of decisions within the Department of Interior in around the time 1872. And while my tribe did experience the restoration of its federal recognition in 1994, this certainly harmed the community and its ability to protect those within the community and to protect children, especially from being removed from their families and from suffering a great deal of abuse that often occurred for those who had been removed. In addition, even in my own generation, my sister was also adopted, and she was adopted a year before the passage of the Indian Child Welfare Act, which also we see as we hope can act as a way to ensure that there are procedural protections that prevent the placement of children outside of their Indian communities. At the same time, what I see when I look at this period of returning home and the work that I would hope that tribal communities could provide, what I also see are many communities that are suffering, that are working very hard to adopt various measures to protect their community against sexual violence and sexual harassment. And in a notable study that Ann Tweedy that completed in 2010, she documented many ways in which tribal communities had enacted legislation and had also worked within their judiciaries to prevent sex discrimination. But at the same time, within tribal communities, what we see are also instances where, on the one hand, tribal criminal jurisdiction has been significantly stripped from tribes, so that until the special jurisdiction that was provided in the reauthorization of VAWA in 2013, tribes lacked any criminal jurisdiction over non-Indians, although many non-natives lived within tribal communities and often were perpetrators of sexual abuse or sexual violence within Indian country. And in addition to that, we also see that even in instances where an individual might want to protect themselves by bringing a civil claim against a perpetrator, tribal civil jurisdiction is also significantly curtailed as a result of the Montana decision, requiring that litigants prove that either the first or second exceptions to Montana be satisfied in order for an individual to be able to bring a claim in tribal courts. So tribal governments do have work that they can do to continue to strengthen and adopt legislation to protect and provide remedies against sexual harassment, as well as sexual abuse. But at the same time, there is this lack of power that we see in the ways in which their jurisdiction has been seriously curtailed in the case of instances where the person committing the harm is a non-native. Of course, we also have, with the special jurisdiction of VAWA's reauthorization, jurisdiction against non-members who are against non-Indians who are involved in instances of domestic violence with a partner, involved in dating violence, and who also violate protection orders. But at the same time, we need to have a greater perspective that, in addition, there are many instances where the cycle of abuse begins oftentimes with children. And we need to be able to ensure that tribal communities have jurisdiction to prosecute perpetrators of violence against children, including sexual violence. In addition, so this is these are just some of my thoughts about the protection that we would look to for within tribal communities and the concerns that I have about the ways in which that ability to provide protection has been curtailed. In addition, I have concerns about the fact that with regard to sexual harassment, this is a workplace concern, and this is often an instance where a remedy would require a waiver of sovereign immunity so that if there is a tribal employer, that an individual can submit a petition claiming that the tribal employer perhaps has some civil liability. And we need to ensure that tribal communities are adopting legislation to provide for these kinds of waivers. What appears to be possible in the future in the area of tribal sovereign immunity is it's certainly possible, not certain, but that the Supreme Court may decide that in a case involving a claim where an individual is harmed due to a tort, that perhaps the court may determine that a waiver or may find a new exception for sovereign immunity in that situation. So I think that we need to ensure that tribes are prepared so that they are not characterized as areas where no remedy is available. Finally, turning to my family or to my storytelling once again, I think of this next chapter as listening to my ancestors, or are they saying we too in addition to me too? So after returning home to Michigan, I did learn a great deal more about my ancestors, which was initially a knowledge that we did not have given my mother and my other relatives' experience of adoption. But later did find that, for example, my mother's mother had attended Indian boarding school, and as did my mother's father, and that these are schools in Michigan which are known for many reports of institutionalized sexual violence against children, and that unfortunately in Michigan, however, if there's significant limitations on the capacity of individuals to bring lawsuits against schools like the Holy Childhood School, Holy Childhood of Jesus School, or the Mount Pleasant Industrial Indian School. Our statute of limitations in Michigan for civil lawsuits brought by individuals severely curtails the amount of time that a person has to bring a lawsuit of this kind for sexual abuse claims that may have been experienced by an individual. And unfortunately, because we have not had a process in the state of Michigan of courts being able to entertain lawsuits with respect to claims of abuse, which experienced in the Indian boarding schools in Michigan. We have not had the process of engaging in identifying the truth of this history and identifying that truth in a way that others can learn from. And I think that there is a very interesting contrast, for example, in Canada, where a lawsuit brought by a class action of survivors of Indian residential schools did result in the formation of a Truth and Reconciliation Commission, a national commission, which ultimately led to findings and recommendations, which included findings that there had been serious examples of abuse, including murder and rape and medical experimentation on children in the Indian residential schools in Canada. I very much would like to know about the stories of my ancestors in the Indian boarding schools. What I do have are records in the National Archives of all places of some of the stories from their lives, because it turns out that from the time that my maternal grandmother was a toddler, she was being surveilled by the state of Michigan, and in the National Archive records for the Mount Pleasant Indian Boarding School, there are about 12 single-space typed pages about the a social worker's perception of her home and the ways in which they found it to be inadequate for the rearing of my grandmother. So I just would like to see some greater recognition of how the Indian boarding schools in Michigan contributed to a cycle of trauma which passed from one generation to the next in the form of intergenerational trauma. There was a study funded by the CDC, which looked at a 25-year longitudinal period, and it determined that there is a remarkable link between childhood trauma, especially sexual trauma, and addiction, depression, diabetes, obesity, incarceration, and suicide. Is this something that we should be looking at for survivors of Indian boarding schools in Michigan and in the United States? I absolutely think that we do need to look at this. And I would like to see some recognition of this history within our legal education, within the broader schools, the public schools that our children attend, And I would like to see some recognition and empathy for this history among those members of the federal courts and especially of the U.S. Supreme Court. Unfortunately, some of the members of the Supreme Court have made it clear that their knowledge of Indian country is sorely, profoundly lacking. And I can imagine that their knowledge of the history of Indian boarding schools, and the way it has contributed to the abuse of children, and the connection that that has to ongoing experience of violence and harassment in the Indian country is not something that members of the court are currently, that a majority of members of the court are familiar with. And so these are some of the thoughts that I have when I think of the Me Too movement in Indian country. I see it as certainly connected to this much longer intergenerational story of trauma in Indian country. And I would like not only for remedies and protection to be afforded within tribal communities through the actions of tribal governance, but also some deeper recognition for this in our non-Indian legal system as well. I'm reminded of the story of one girl who, at the age of 16, was attending the Mount Pleasant Industrial Indian School in Michigan. And in 1899, she set fire to she set fire to the laundry room where she worked. The curriculum for girls was to learn to sew and to learn to do laundry and to learn to cook and learn to set a table. She set fire to the laundry room. It was put out. She then set fire to the school building. The school building was destroyed, even down to its cornerstone, and required complete rebuilding. And a couple weeks later, she set fire to the dorms itself. She did everything that she could to destroy the school, where she and so many of her classmates were forced to be separated from their families and to live in an environment where there were many stories of abuse and violation and physical harm for these students. I think of Martha Shaganaby, who confessed to these crimes of arson in 1899, and her desire to burn it all down. What I would like is maybe not to burn it all down, but to at least begin a future where there's some greater sensitivity to this history and greater insight into the cycle of intergenerational trauma and the ways it contributes to sexual violence and sexual harassment in Indian country. Miigwech.
Thank you, and thank you for sharing those stories as well. Professor Riley, you want to take over? Professor Fletcher?
Oh, I am?
Yeah.
Oh, is that what you want?
I was going to see if you have to leave sooner. Do you want to take a couple questions first?
Oh,
Because then you won't get a chance to answer questions from the audience.
sure. I'm planning to leave at about 1:20.
Oh, okay.
So, but I probably won't be able to make it to the end of the panel.
Yeah, maybe we'll just take some questions now.
Okay,
Sure.
sure. Happy to take any questions. Yes.
One question.
Contact's kind of filtering this morning, so I apologize if this is not formulated very well. You were talking earlier about state-recognized tracts and kind of like vehicle protections and things like that. And I went to an ICMO roundtable in Los Angeles over the summer. One of the things we were talking about is how they wanted to try to use ICMO to apply for 2 state-recognized tribes in California and maybe try to do a little bit more to impose ICMO for urban Indians. And I just kind of want to sort of see where you feel like, what's your view on states maybe taking more proactive measures towards where there's clearly a huge gap in federal protection?
Were you saying with regard to ICWA? I'm sorry.
Yes.
Yeah, I think that Well, certainly I'm in favor of the broadest, strongest possible implementation of ICWA fully in compliance with the terms of the statute. And so there is some concern. ICWA refers to an Indian child, and an Indian child is somebody who is either enrolled in a federally recognized tribe or is a child of parents who are themselves, where one of the parents is enrolled in a tribe. And one risk is that with regard to ICWA-like protections that are different from protections for other non-native children, that if it's not connected to enrollment in a federally recognized tribe or being a child of someone who is, then there are possible constitutional challenges that could be raised with regard to that based on the equal protection, And so I think that that's a potential risk, but I do think that in general for any tribe that is for federally recognized tribes, absolutely ICWA needs to be enforced fully in compliance with all of the various requirements of the statute as well as the regulations that have been issued that interpret it. Do you have any thoughts about that you want to add, or do you, Monty?
No.
Other questions? Okay, Miigwech.
Yeah, I just want to say thank you to Professor Singal for squeezing in the scheduling change. She does have to leave early to catch a flight, so we appreciate you taking the time.
Next.
Sure. All right. Hello again. My name is Matthew Fletcher. I'm here really to talk about the Indian Child Welfare Act as well. So my paper idea is going to change somewhat. And it was going to I think it was going to change anyway, but last night a judge in Texas declared the Indian Child Welfare Act to be unconstitutional on several grounds. Well, really two grounds. And so I'm going to talk a little bit about the doctrines at play, and I think I'm going to put together a paper that is effectively a draft amicus brief for responding constitutionally to these questions. This is a conference on the Constitution, so I'm going to focus on that. So that's effectively what I'm going to do, but I would like to start a little bit with an Anishinaabe story. Winona and I, and well, actually Angela as well, we're all Anishinaabe people. And there's a wonderful series of stories involving the trickster god, his name that I like to call Nanabuju, which is a sort of a variant. His real name is basically Big Bunny. He's a big bunny. He's a shapeshifter. And he's got multiple stories of a coming of age story. My favorite one is about this terrible situation where Nanabuju is just a little baby and is living with his grandma Nokomis. And so a giant comes to the Anishinaabe Key, the world of the Anishinaabe people, the land of the Anishinaabe people, and just kills everybody. And Nokomis and Nanabuju are sort of spiritual creatures, they're mythological creatures, superpowers. Nokomis shrinks Nanabuju down, who's already a small kid, into a tiny little creature and puts him in the ground underneath a tent peg, basically, and hides him there from the giant. And incidentally, this is a separate question, incidentally, that's where Nanabuju learns how to shapeshift and become a rabbit, but that's another question, another day. And Nokomis and Nanabuju are the only Anishinaabe people to survive the attack of the giant. The giant kills everybody and steals their hearts and goes back across the sea, imagine Lake Superior, Lake Michigan, that kind of sea, to the giant's enormous lodge. And eventually Nanabuju comes out and grows up, and part of the thing that happens with Nanabuju is he grows up and becomes strong, and You know, he's like a superhero. He's going to go do something about this giant. The thinking is just to go kill the giant, get some simple revenge. The Nana Buju needs help from the Grandma Nokomis, and that's part of the story too. But one of the great features of this story is how each of the 7 clans of or groups of clans of the Anishinaabe people who are affiliated with various kinds of animals help Nana Buju. And in fact, if any one of those clans didn't supply some form of assistance in some way, the whole project would have failed. So at the beginning, Nana Buju receives help from the 4-legged clans. That's where all the food comes from, the supplies, how to make the canoe, the jiman, to get across the ocean, get across the big lake. Fish clans, the turtles, provide pitch to make sure that the jiman is seaworthy, effectively. Nana Buju has supplies, has weapons, ready to go, has a canoe, goes to the giant lodge, the fortress, really a castle of the giant. And when Nana Buju gets there, the bears, the Mukwa, are the guardians. That's one of the things they do. They're healers, they're defenders, they're the police, they're guardians. Mukwa is guarding the lodge for the giant. And Nana Buju's got a big, he's got a war club and spears and stuff, bows and arrows. He could kill the bears, but instead he offers tobacco and talks with the bears and finds out the bears are actually there because they've been enslaved by the giant. And if anybody was nice to the bears, as Nana Buju was being, then they would help out. So the bears actually say, look, we're going to let you pass. You're nice to us. You will free us if you kill the giant. And by the way, there's a whole defense system behind us that has to do with all these birds. So watch out for those guys. Birds are not to be trusted. And so Nana Buju was like, thanks a lot. So, the bear is another clan. Now we're up to like 4 clans, right? We've got the 2 four-legged clans. We've got the fish clan, the water clans. We've got the bear. That's 4. They're all helpful. There's 2 more bird clans, and then actually 3 more bird clans. I'll get to those in a moment. So the next, so Nana Buju is inside the forest and sees basically what are loons, right? You know what a lunatic is, right? Somebody who's crazy and makes lots of wild noises. That's not really what a loon does, but they're creatures that have this weird sound, and they're effectively for the giant our warning system. And Nana Buju leaves tobacco for the loons and actually paints them. If you know what a loon looks like, it's very incredibly well designed. It's very pretty. And so Nana Buju basically bribes the loon into not issuing their early warning system. And then Nana Buju gets to the next level of birds. And these are the ones that I like. My middle name is Migiziwas, which means white eagle. It's sort of the egotistical, arrogant, flying creatures that, we really need to have them around. We want them around. And that's the eagles, the cranes, they're sort of the international speakers. So it's another warning system, same kind of thing. Nana Buju offers them tobacco and talks to them and tells them, when I free all of the animals, which is what this part of this goal of killing the giant is, I'm going to release you too, and you'll be the leaders, which is exactly what birds like eagles and cranes like to hear, that they're going to be the ones in charge. So Nana Buju's like, all right, let me go. And so that's almost to the end, and there's no warning. So this giant who's just been sitting around eating Indians and is very fat and lazy and sleeping is actually easy pickings for Nana Buju. He's got that weapon and he kills the giant, no problem whatsoever. And he finds, however, that the giant really did take all of the hearts of the Anishinaabe people that he killed and kept them in a big bag on the ground. And that's where the last clan comes in, because Nana Buju brings that bag back to Anishinaabe Key across the ocean. The sturgeons, who were part of the fish clan, help him bring this enormous thing across the ocean, this huge bag of hearts. I know it's kind of gruesome. It's like a horror movie. And then when they get home, Nokomis calls the Thunderbirds, Anamiki Benisi, and the Thunderbirds strike the bag with vast amounts of lightning. It's almost like a giant defibrillator, and all the Anishinaabe people come back to life. And that's sort of like a coming-of-age story and a creation story about Nana Buju Anishinaabe people have. But the great story, what I'm spending a lot of time telling you about, is that Indian people have always faced enormous obstacles. And part of it is, Winona is describing one of those obstacles, and right now there's another one, a huge giant, so to speak, metaphorically, is this attack on the Indian Child Welfare Act, which, to be frank, is an attack on Indian law and Indian tribes and tribal sovereignty in a very fundamental way. And it's an enormous undertaking to deal with this. And we need all of the 7 clans. The clan system, at least in part, is a leadership structure. You have to have all of the clans working in tandem. I know those cranes and those eagles are the leaders, right? That's what they think. They're the big, loud-mouthed ones who fly around and look down. But all of the clans work in tandem, and each of them has a contribution to make. And so right now we have this issue in Indian country where we have the giant is coming, right? The giant is here and is striking down things like the Indian Child Welfare Act. And without going into detail, because I'm supposed to talk about this case, not this other stuff, but without going into detail, the clans haven't organized yet. And I don't think people realize what a serious question this is and how difficult it will be. There's a guy who's going to be confirmed, if he isn't already at this moment, but in the next day or so, I can see that guy writing an opinion in the next 2 to 3 years that begins with a phrase, the Indian Child Welfare Act is unconstitutional. And you have to expect, if the clans don't get together and cooperate and bring the full force of Indian people together, it's not just Anishinaabe. Most of the tribes in the United States have some sort of leadership structure that's similar to this. They have to come together to stop that from happening. So, let me tell you a little bit about this case in Texas. It's called Brackeen versus Zinke. It's really the state of Texas bringing a lawsuit against the Department of Interior and the United States government, direct constitutional challenge to the Indian Child Welfare Act. So last night, a federal judge, a very conservative federal judge, they picked this judge on purpose. If you're a state, you get to pick judges more or less if you're careful enough, and they're very careful. This judge said that the Indian Child Welfare Act violates the equal protection component of the Fifth Amendment and also violates the commandeering prohibition that is inherent or implicitly contained in the 10th Amendment. And along the way, the judge said, and by the way, those precious regulations the Obama administration crafted a few years back, those are totally invalid from their inception. And also, the last couple of paragraphs of the opinion are, and by the way, don't even come run into me with the Indian Commerce Clause, because that is also doesn't authorize the Indian Child Welfare Act. So that's where we are right now. This is Texas. The parties are foster family, Indian children who are eligible for membership or are members of Cherokee Nation and the Navajo Nation. The United States government is the defendant. Now, as a procedural power politics kind of matter, if you're going to have Indian tribes who are as motivated as anybody in the country and have resources and the wherewithal to fight this thing all the way to the Supreme Court, it is the Cherokee Nation and the Navajo Nation. Those are 2 of the tribes you want on board. There are other tribes that are part of this as well. I think we just put a press release from those tribes collectively on Turtle Talk just a few minutes ago. You also want that the federal government, the United States, is a defendant. It is a party. They're defending, it's their statute. So they are the lead defendant, of course. And you want the United States Department of Justice on your side defending this case. So as a matter of power politics, it's not just the state of Texas, and I think a couple other states signed on with this case as well. So this is a question, and absolutely is a question of important American constitutional law, huge power players at stake. If this case will go up on appeal to the Fifth Circuit, and if they affirm, there's no doubt in my mind this has to go to the Supreme Court because it's a federal statute that's being struck down. So, I haven't even gotten to talk about my paper, and I'm only going to basically give you the broad outlines of it. I'm starting to formulate what effectively is going to be a draft amicus brief from, a law professor kind of thing as we move forward in this case. So I told you that the issues, at least according to the federal judge, that are most important are this equal protection issue relating to arising out of the Fifth Amendment and the 10th Amendment issue. The rest of it isn't all that important. So the equal protection question is really interesting. This is about Morton versus Mancarry. Morton versus Mancarry is a critically important law, is doctrine or case in Indian affairs. It basically says when Congress acts in perpetuating its trust relationship with Indian tribes, it is authorized to take broad action. And Morton versus Mancari itself is about the Bureau of Indian Affairs hiring preferences, but Morton versus Mancari also authorizes as a recognition of the Congress's broad authority to implement its duty of protection, its relationship, originally based in treaties with Indian tribes. Most of those treaties at the very beginning, if you read them, include the term or word protection or duty of protection. And what that means is Indian tribes have come under the protection of the United States. And if the United States legislates on behalf of Indian tribes, and often to the detriment of Indian tribes and individual Indians, it's authorized by this duty of protection. This is separate, effectively, than the Constitution itself, although you can make a good argument that there is a connection, certainly. This is the response to the Fifth Amendment claim from the state of Texas that was adopted by the federal court. The only way this Fifth Amendment claim works on the equal protection issue is if there is no Morton versus Mancari. So that's definitely issue number one, a critically important issue in this case. It is an abject rejection of Morton versus Mancari. And I'm going to pause for a second to tell you that that's really important. This is the kind of thing that is an existential threat to Indian tribes and Indian people. The second one, 10th Amendment, commandeering. This one I find to be completely ludicrous. A few months ago, there were motions to dismiss filed that were rejected on the question of standing. The state of Texas, or the federal government said the state of Texas suffers no injury when it is required to comply with the Indian Child Welfare Act. Texas's best argument in that particular stage of the litigation on that question was, if Texas doesn't comply with the Indian Child Welfare Act, there's a slight possibility that the federal government will deny Texas what is known as Title IV funding. This is funding that the United States appropriates to every state to help pay for foster care services, not just for Indians. So the United States, if it wanted to enforce the Indian Child Welfare Act against a state, it could certainly bring a lawsuit, but it could also just, as Texas is alleging, threaten to cut off or reduce Title IV funding. Okay, so that's Texas's injury. Now come back to our case from last night, the commandeering question. Commandeering is where the United States Congress passes a law that forces states to act in a way they otherwise wouldn't have done if they had their own wherewithal. It's the commandeering of a state's legislative functions, its policy-making functions, and I guess in theory its judicial functions. So actually this is a pretty strong argument. Right? I mean, it's basically, the Indian Child Welfare Act does require states to take certain actions they normally wouldn't do. As a political matter, this is basically Texas telling a federal court, look, ICWA is telling us to do things like give due process to people and let them have attorneys, and we don't want to do that. There was no way we would ever agree to do that. You're commandeering our legislative function. We just want to run roughshod over people's rights. And the federal court said, yeah, Texas has a 10th Amendment right to do that. The problem in this context is that if it is true that Texas's injury is that they might lose federal funding, that is actually an additional source of constitutional power. Do you guys remember Obamacare? When that case came down, remember there were 4 conservative judges who said this violates the Commerce Clause, and then there was that one conservative justice, the most important one, Chief Justice Roberts, who said, I totally agree with you, this is not authorized by the Commerce Clause, but really Obamacare is enforceable through taxes. Congress has independent power to tax and spend, and they can require states to do certain things so long as it is tied to the spending of federal tax revenues. So that's really what Title IV-E is. It's a really weird disconnect in this case to hear a few months ago Texas saying we're going to lose our federal funding, and then a few months later argue that it doesn't matter, this commandeering argument. They cancel each other out. The tax and spend issue should defeat the commandeering issue. I may be wrong about that. I'll write an article about it and you can disagree with me. There's more. I'm not going to get into, I've been talking too long already, so it's been 20 minutes. But what I want to leave all of you with is that this is a serious moment in Indian law. And for a lot of different things. ICWA, and I will tell you this, and I've been saying this for years, we have a clinic that focuses pretty exclusively on the Indian Child Welfare Act. It's as you can tell from Professor Single's stories, this is deep, near and dear to our hearts personally. We'll go down in flames with ICO if we have to. That's the reality. But we're rare. There's a reason it's really only Michigan State. That is, and you know, people like Winona and Kate Ford and our students who are standing up. I mean, Kate is the one who's really organizing and getting these tribes involved. And let me tell you why that is. If you win an ICWA case, you don't get attorney's fees. It's not a civil rights action. It's not an environmental case. There's no citizen suit here. You don't get paid if you win. It is nothing but costs. And that's critical. That's why Native American Rights Fund, they're awesome, but they can't spend a lot of their resources helping us out because they need those attorney's fees. And the other part of this is that national organizations like National Indian Child Welfare Association and National Congress of American Indians, they just haven't really been doing a very good job in dealing with this nationally. And I'll tell you, I don't know why that is, but I know that it is. Did you know that this is the 40th anniversary of the Indian Child Welfare Act this year? Has anybody even thought about that? You know who's had a conference this year about saying it's the 40th year of the Indian Child Welfare Act? The Cato Institute, the Goldwater Institute, they're on top of it. They're issuing press releases every time a new case comes out on ICWA in which they lose. They are all over this, and it's crickets from Indian country. It's time for that shit to stop. That's why I give you my story about the clan structure and how we need to get together. I mean, we got the lawyers. We can do this stuff. We can file the amicus briefs. We can get the tribes organized. But we are not a public relations firm. And that is what Indian country so far has been asking from groups like an Indian Law Clinic in Michigan. We need to do a lot better than that. And maybe you guys are the wrong people to talk to, but I know you're not. You're absolutely the right people to talk to. And I appreciate the opportunity for this, definitely the law review for a chance to speak about this. Miigwech.
All right, can you hear me? It's up there. Okay, great. Well, good afternoon, everybody. Thank you for being here. I'm Angela Riley. I want to start by recognizing the tribes of this region, and thank you for letting us be guests on your land. Thank you to the Law Review and to the law school. I have taught a couple times in the summer program here, and I really love Missoula, and I love the law school, and all the people that I've met here have been amazing, so I'm happy to be here. I'm hearing a weird echo. Are you guys hearing it? Is it distracting, or is it okay? All right. I can't tell from up here. So the other thing I was just going to say, just to start out, is that it's always so fun to come and do things like this, because I've been doing this now for a long time, and it's always like a mini reunion. So we all have known each other, most of us, for a very long time and do this kind of work together. So if you are a student and thinking about going into this field, and I hope you are, I just want to add one additional plug for being in the field, is that the people you meet now, especially in law school, are going to be your people forever. Winona and I went to law school together. I've known Matthew for 20 years. Rebecca Sosi, Frank Pommersheim, the list goes on of all the people in this room who have taught me and I've learned from and have been colleagues and supporters. So it's a really incredible community of people. So I'm going to shift gears a little bit in terms of my talk today. You can see it's about Good Native Governance 2.0, Native Nations in the Era of Trump. So I'm going to talk a little bit about sort of what the current situation is and how we might think about moving forward, instilling that little nugget of hope that Professor Pommersheim mentioned earlier this morning. I also just wanted to give a couple of disclaimers. So one is this isn't meant to be an exhaustive presentation, so I'm not telling you everything that happened in the Obama administration, nor am I telling you everything that's happened in the Trump administration. It's really just kind of a scratching of the surface. I've done some of the research, but certainly not exhaustive research. I didn't really come in here with any intention of being partisan about the presentation, but I couldn't really find any good things that the Trump administration had done for Indian country, so forgive me, and if you know about them, please email me. I will include them in the paper.
So this is what I'm going to do. I'm going to give a little bit of the context of Indian country under Obama, then a brief sketch of what I think the impact of the Trump administration has been on Indian country thus far, and kind of look at what might be on the horizon, and then also then kind of wrapping up thinking about the future. Would you mind if I use your mic? I'm sorry, but it's really distracting me, if not you. I hear this weird echo. I can just hold it.
Yeah.
Is that okay? I'm sorry to be difficult by not sitting down. I feel the need to stand up, so I'm going to stand up. Maybe it's a short person's thing. Like I need to be seen somehow. All right, so nope. Nope. Sorry.
Interesting. That's one way to get up.
Does that do it? No.
Let's try it again.
You want to just open it up?
Yeah, I just can't get it to be. So. There. Okay, then it's just like that there, and you can click that. There you go.
Yeah. Okay, thank you.
Yeah.
All right, here we go. So just thinking a little bit about the transition from the Obama administration to the Trump administration. And again, not exhaustive. These are just some highlights. Part of this comes out of my own research and my work. So if you know of other things that you think should be mentioned, again, feel free to let me know. Just a few things that come to my mind. One is this is a photograph of President Obama signing the Tribal Law and Order Act in 2010, which was instrumental in Indian country. It increased tribal sentencing authority. There was also the reauthorization of the Violence Against Women Act in 2013, which expanded the category of people who could be prosecuted by tribes for domestic violence, including non-Indian perpetrators. The Obama administration, partially as part of the Cobell lawsuit, brought enormous numbers of acres of land into trust, something around 500,000 acres. The administration, as Matthew mentioned, issued regulations regarding rights of way in Indian country, on the Indian Child Welfare Act, and on federal recognition to try to streamline some of those processes and improve them. As you know, one of the big fights leading up to the election was the standoff at Standing Rock and the peaceful protests that happened there. The Obama administration had declined to grant the easement going under the lake and didn't authorize the completion of the pipeline at the time. He also designated Bears Ears as a protected monument under the Antiquities Act in 2016 and authorized the tribal co-management of that project, which was pretty unprecedented. Just to contrast that with a few of the things, a few of the things that have happened under the Trump administration. 4 days after his inauguration, he issued the executive order to advance the approval of the DAPL pipeline and to expedite the environmental review. And 2 weeks after that, the easement was granted. Shortly thereafter, I guess almost a year after, in December of 2017, you probably know, he modified the borders of the Bears Ears monument, which is sacred to the tribes of the region. You all are probably familiar with this story. The reduction was by about 85%, and the New York Times reported that the exploration of oil and gas was a driving motivation for this, and they have this documented with emails and other evidence, and this is still currently tied up in litigation. Another thing, of course, is that the Trump administration reversed course in terms of taking land into trust for Alaskan Native villages. There had been a long battle about the possibility of recreating Indian country in Alaska outside of the Metlakatla Reservation. Through a whole series of cases, including a case called the Keachak, and then eventually a stand down by the state of Alaska, it looked like there was going to be the possibility of taking land back into trust for Native villages, which could be incredibly important for those for those tribes and those people, again, along the lines of things that both Matthew and Winona have talked about, but particularly in violence against women, and the ability to address and really deal with some of the more remote and isolated communities in Alaska. The presence of Indian country could be instrumental in changing some of those dynamics. The Trump administration reversed course on that issue, and then just a few days ago, also reversed course on an Obama-era decision that the Wampanoag in Massachusetts had land in trust under the Indian Reorganization Act, and reversed that as well. So, in addition to all of these things, from my point of view, the overall tone has been filled really with derision and racism. Some people trace this to Trump's early hostility towards Indian tribes because he didn't want to compete with tribes in the casino business. I don't know if that's true or if that's why. But on many occasions, the language that's come out of this administration and out of our own president's mouth involving or relating to Native people has been, in my view, nothing short of racist. Regardless of your personal feelings about Elizabeth Warren and her identity quest, the fact that he calls her Pocahontas as a racial slur is just a devastating thing for Native people and for Native women. This, as you know, when he honored the Navajo code talkers, that was on one occasion where he went off course from honoring them to go on a little bit of a tirade about Elizabeth Warren in that moment, in my view showing them enormous disrespect and showing disrespect to the purpose that they served, fighting for the United States. He also recently gave an address where he said that colonizers tamed a continent and we're not going to apologize for America. So, no finessing of the language or any kind of acknowledgement of what taming the continent meant for us and for our people. In more general terms, there are just some basic kind of administrative functions that are happening in DC that are really destructive to Indian country right now. As many of you know, not just in regards to Indian affairs, but in regards to many cabinet-level positions, a huge number of them remain unfilled. It's about 50%, depending on the particular agency. The same thing is happening in Indian affairs. In a lot of the positions where people are being put in, there are people who are being strategically picked to dismantle the organization that they're picked to lead, as opposed to lead it. This is very intentional, I think. There's great documentation about this process and what's been happening. There have been so many books. Michael Lewis, the author of The Big Short and Moneyball, he's a great writer, just released a new book called The Fifth Risk, where he talks about this phenomenon happening in 3 different sort of departments, broadly speaking, in the Trump administration. And one of the places that he talked about that I found really intriguing in the book was that he's left a lot of people, in the Department of Energy, for example, one of the very first things he did was put people in place who would not be opposed to the fossil fuel industry, and he immediately sent out a list of 74 questions so he could identify people who had been in meetings about climate change. Again, because of the agenda around extractive industry is the presumption that that's why that's happening. It really signaled that the new administration doesn't agree with the attempts of the U.S., which has been our stated policy, to try to wean ourselves off of fossil fuels and to explore more renewable sources of energy. This obviously goes directly to issues of climate change and what's happening in the world and across the globe in regards to climate change. And the evidence shows, and I do a lot of work with the United Nations and do work with indigenous peoples around the world, that indigenous peoples in the U.S. and beyond are going to be the first victims of climate change. We already have climate migrations happening across the globe. And because many indigenous peoples, of course, live in the developing world, which are the poorest countries in the world, they often are the most vulnerable to these actions. Even the family separation policy, many people who are indigenous rights activists pointed out that many of the people who are being separated at the border are also indigenous. They may not be members of American Indian tribes, but many of those people crossing are indigenous and are fleeing violence and poverty. And as was also brought up this morning, if the wall is being built, at this point I don't know what the state of the wall is, but one of the places it would cross would be the land of the Tohono O'odham, who have expressed their disagreement with it. Of course, one of the most important places that he's impacting the United States, and probably Indian country in particular, is filling the judicial appointments. This is really the most concerning part, in my view, because this presidency will not last forever, but Article 3 judges have lifetime appointment, as you know. As of today, he has made 140 nominations, and there have been 68 confirmed. If we keep going on this course, he will be one of the leading presidents in terms of the number of judges he's been able to appoint during his term. Right now, he's already 6th, I think, in the history of the U.S. And of course, not to mention the Supreme Court. Matthew Fletcher has done some great analysis of the work of the justices who have been nominated. He has, on Turtle Talk, a review of Gorsuch's opinions. There's not much out there on Kavanaugh in regards to Indian law, although Matthew did point out that he filed an amicus brief for a conservative anti-minority rights coalition in the Rice v. Cayetano case. So that, I suppose, just remains to be seen. But all of that said, I'm going to give a nod to Frank Hammersheim and say, well, we have to have hope, and here's the hope that I see coming out of this. For one thing, it's galvanizing Native people across the country to stand up against what many people see as a tyrannical government. Just in regards to Indian country in particular, there's an unprecedented number of Native people running for office. Many of these are women. I have some pictures of them here. My research says that right now there are Native people in 3 governor's races, 4 congressional elections, and then 31 in state elections around the United States. So this is a really powerful and positive change. To return to the Elizabeth Warren point, I just met with Deb Haaland, who's running in New Mexico, and I hesitated to say this publicly, but I guess I'm going to say it. Elizabeth Warren's office had reached out to me, and I think reached out to other people too, because Winona's not here, but she probably reached out to Winona, partially because there was a group of us who were Native students at the law school at Harvard when she was a professor. So kind of through some of those communications, I got the impression, as I'm sure you all know, that she is very much considers herself an ally of Indian country, and very much considers herself a person who I think at this moment, probably, I'm going to give her the benefit of the doubt and say I think she actually genuinely is an ally, and I think she also really needs to change the PR story around her identity. She gave a pretty powerful talk at NCAI, which you might have seen the transcript of, and got a lot of support in that forum. But I was really curious, and I asked Deb Haaland if Elizabeth Warren had reached out to her, and she said she had, and that she had been an enormous supporter in her and in her run for Congress. So I just say that to say, I love seeing all these Native women running for office. I love seeing Native people in general running for office. And I do think it's important, and this kind of goes to Matthew's point as well, not just that we band together as Native people, but that we take allies where we can find them. You know, we're a very small percentage of the US population. We really have to work in coalition. And I think that's something that we can do better at, and I really think we are getting there. The other thing, just on the point of hope that I want to close with, is that, you know, this presidency is not going to last forever. And as Matthew and Winona both mentioned, we've been through so much. Native people have been through so much, and yet we are still here. And we have had enormous resilience and success. And there's no reason to think that that has to end as long as we sort of keep our eye on what's important. As you all know, we are really seeing an indigenous rights movement all across the globe, and American Indian tribes are part of that. Standing Rock really exemplified that indigenous people from all over the world identified with that struggle and supported that struggle. The UN Declaration on the Rights of Indigenous Peoples, of course, is an aspirational document and perhaps an unenforceable one, but it is being talked about in terms of real substantive rights that can be realized, even in the United States. And there are groups of people, led by people like Walter Echo Hawk and Greg Bigler, who are really trying to figure out ways to more concretely operationalize the Declaration in American law. There are human rights mechanisms, like the Expert Mechanism on the Rights of Indigenous Peoples, who are doing work all across the world with indigenous groups, including in the United States. I want to just make one more mention of Frank Pommerstein's book he wrote several years ago about constitutionalizing Indian rights, and has a very provocative and thought-provoking suggestion in that book. And maybe I'll let him tell about that instead of me telling about it. But I just wanted to bring that up in light of the things that Matthew was talking about with the challenges to Morton v. Mancari and the potential to undermine the entire body of Indian law based on equal protection challenges, which I agree with Matthew is an existential threat. So thinking strategically about the ways that we can really protect ourselves going forward, particularly because I think the biggest consequence of this administration is going to be an enormous shift in the federal judiciary. So we have to really think long and hard about how to prevail there. Thank you. My question.
So thank you to our panelists for some perhaps depressing but also thought-provoking presentations. And I'd like to continue on that score about sort of looking forward, particularly in the context of the ICWA case, but it seems more broadly, the trends across the state of the law with regard to race and racial distinctions has been away from recognizing rights that are fundamental in Indian law. I wonder if, with regard to Morton v. Mancari and the challenges presented by the Texas case, whether that also presents the potential to rethink broader questions of American jurisprudence, or if that's just too far to go and we need to win this case first.
Yeah, so I realize that Winona and I kind of came in and gave you some downers, and Angela did too a little bit. But I want to highlight a few things. We always have to remember Indian tribes are timeless entities. I always tell our students that. They're going to outlive us. This is actually, Indian people know this. They don't like to admit it because we all have to admit that we're going to die. But our communities will last beyond us. And right now, anyway, our tribes, our nations are the thing that is going to survive. And that's really critical. That's for our future generations. And I love to look back just like 1 or 2 generations. The tribes in Michigan, our modern existence really came into play during the treaty rights era of the 1960s and 1970s. Our adversaries were the state of Michigan and a whole bunch of racist white fishermen. And we had a really difficult time in fighting those guys. They're powerful. They can go to and almost instantly get congressional hearings to have our treaty rights abrogated by Congress, and they tried to do that. But you know who are, now that the treaty rights cases are settled, a few decades into the future, now the current president, our biggest allies are essentially the successors in interest to those racist white fishermen. They're the environmental organizations that were also sort of quietly siding with those fishermen against the tribes. Now they're the biggest ally of tribes, and vice versa. And tribes are, I think, really are, I don't know if they're doing it on purpose or it's just the way the world has changed, they really are at the forefront of some really critically important fights in existential threats to humankind. Standing Rock was a part of that. Keystone XL is a part of that. We've got Line 3 and Line 5 in the Great Lakes on the pipeline stuff. There's Bears Ears. tribes are interested in all these things for their particular reason, but these are just good policy choices for people and entities who are interested in humankind continuing to exist in the foreseeable future. And you know who is not on the side of humankind continuing to exist are usually the people interested in, relentless oil and gas and fossil fuel extraction and mineral extraction and reducing pollution guidelines. And the great thing about where tribes are right now is that they're on the side of humanity. And everybody wants to be aligned with the tribes. And it's such a sea change, an interesting sea change since when I was a kid, and everybody hated Indians. And now it's starting to turn. Tribes are governments that are actually operated, for the most part, most tribes are operated by people who grew up poor. Is your government, your non-Indian government, ever really populated for the most part by people who grew up poor? I mean, you had Kavanaugh up here a minute ago. That dude didn't grow up poor, right? I think that's just incredible that there are these governments, some of whom have vast resources, some of them don't. Some of them have pretty significant resources and political power who are actually governed by people who are outside of the typical structure of the United States. I mean, the Constitution is designed for white guys in power to keep white guys in power. And Indian tribes are total change. I mean, we even have some of the same language in our Constitution, but our government structures, or the way our governments govern, is really quite remarkable. And I find that just exhilarating every single day. So fuck despair.
Well, can you hear me? I mean, I guess I'll speak a little bit more doctrinally just on the Morton v. Mancari equal protection issue. I do think that there's an enormous risk there. Unfortunately, I think ICWA might be the weak link. In terms of going after a statute on equal protection grounds, I think there's some parts of ICWA that are problematic to people outside of the field. There are places where the statute refers to Indianness as opposed to just tribal identity. There are places where it's vulnerable to critique. And I think, one of the things that's interested me, if not concerned me, is how and to what extent we're able to devise really persuasive responses to those particular points of criticism. I think also because ICWA involves Indian children and the issue of, from an outsider's perspective, of Indian tribes are trying to prevent people from giving Indian children better lives than what they can give them, which is the rhetoric that we hear and how we respond to that. It also kind of goes to the question of how we define Indian, and I think that's something that obviously Matthew talked about with the restatement, but we also heard this morning in Barbara Creel's presentation. That question actually pervades a lot of what we do in the field. And is a very vexing question in a lot of ways, because any category we use is by definition both under-inclusive and over-inclusive. And so I don't know that there is any kind of uniform answer to that, but just looking at the very first line of the Baby Veronica case, which said this is about a child who is, and named a percentage and a fraction of what percentage blood she had of Indianness. We live in a complex, globalized world. Native people are like all other people. We interact with the world. We're engaged in commerce. We go away to school. We come back. People intermarry. So we have to also be very committed to, and I think principled about, our own ideas of who is our tribe and how we define our community. And I think a part of that is dealing with this question of blood. And when I go outside of the United States, it's really interesting to me, because in other places in the world, I was just in Australia this summer, for example, you would never ask a person how much blood they had or what their blood quantum was. It is considered to be an unbelievably offensive thing to ask someone, as if they're like a quarter horse or something. But in the US, and believe me, I'm Angela Riley, so I'm mixed, in case no one picked up on that. I get the first question I get out of people's mouths all the time: how much blood are you? what's your blood quantum? What percentage are you? And it's really amazing. And I think a lot of that is education, lack of education in the United States, a complete misunderstanding about the processes of colonization that got us to where we are today. So I think part of it is, I always look to, in my research, what I've tried to do and what I've tried to do in my writing is think about what can tribes do? Instead of us reacting to the world, which we've had to do for so long, a lot of tribes are positioned now to actually be proactive and to live sovereignty and to move the needle in their own way with a strong commitment to sovereignty and self-determination. So what do we want? How do we see it? And I think, again, with Barbara Crill's presentation this morning, that's one of the things that I've thought a lot about criminal justice in Indian country is, what do we want? If we're designing the system, what does it look like? Because we can design the system now. Not every tribe, not in every case, but there are tribes that can design the system now. They can design their own system. And I think that's a very empowering place to be. And I like to think that we could start from there as our core value and move out from it.
So we have about 10, 12 minutes left or so, and I'd like to open it up for questions and further discussion.
Speak loud. Talk loud. Say nothing.
Hello, thanks for being here. We've heard a lot today about federal governance opening country, but as a tackle on native governance, I'd like to get some of your thoughts on some internal functions that tribal governments can do to advance some of the interests that are at stake that you're discussing here.
Mm-hmm.
Well, I mean, it depends on what questions you're asking. I think one of the great things in the Indian child welfare arena that tribes have been doing is, the way that what happens is if there's a house that's dirty and the parents are doing really poorly and they have to call CPS and they come and they take the kids away, under the state system, there is a enormous amount of financial and political pressure that towards getting those parents out of there, terminating their parental rights, basically treating them like criminals and removing them from ever and severing those kids from their parents. That is, I mean, the stated goal is reunification, but the reality is it often ends up in these parental termination hearings. And that is it. That is an absolute severing. You will never see your kid again and vice versa. But one the great things that Indian tribes have done, and not all of them, is they said, look, there are times when we got abuse situations and terrible neglect situations where, yeah, after a long period of time, reunification just isn't going to happen. The tribes don't terminate parental rights forever. What they do is they say, look, this kid's going to go to a permanent placement with another person, another family, another parents, whoever it is. But this Indian country is small. We all know who the mom is. We know who the dad is. It's not like we can ignore that. And they still may be, over time, maybe even decades, become part of, to rejoin that family. The family may one day be reunified. And there's always that sense of hope. And tribes have cultural adoptions that they do. They bring in a lot, with Indian child welfare, they bring in a lot of their traditional teachings and ceremonies that I think are really quite remarkable. And that's just one example of some of the things that tribes do that I think is really quite incredible and creative. And you don't have to be beholden to, the policies of the state and federal legislatures. You can do what you want. I think that's the best thing ever.
I would just add to that I agree with what Matthew is saying, and I think, there are a lot of conversations amongst people, again, around the Declaration who are trying to think about how to implement it in American law. And some of those people are traditional teachers. Not everyone is. It's a very diverse and mixed group along age and geography and other ways. But one of the kind of core values that's come out of that conversation is that many of the people in that group believe, and I also believe this, that the reason indigenous peoples have survived for so long in the face of such devastating colonial forces is because of a shared indigenous culture and belief and lifeway. And if we lose that, then I don't think that we actually, I think that is where our strength lies. And so for me, when you say, what can tribes do, in my experience, and in many cases as an outsider to other tribes that I've worked with or have friends there or whatever it is, that the core strength is really what makes you who you are. What makes you Anishinaabe, what makes you Potawatomi, what makes you who you are, that is what keeps you moving forward. And in my view, if tribes can do anything, they have to do that first. That is where I really believe the power is. I think the judge had a comment.
Not to put a negative twist on it, you just brought up not only the blood quantum idea, but also, solidarity between tribes. I know, or Professor Mills and other, that, it's basically been put on tribes from history, from gods, et cetera, from way back. But now, of course, you have a problem with disenrollment when it comes to, keeping money in larger amounts and larger senior members of the tribe, even posthumous disenrollment. I hate to put a negative twist, but I want to see is there anything going better in that avenue of tribes law?
No. Yeah, there is. It's there. Yes, it's been a thing. 5 years ago, people were saying, like David Wilkins, who's a political scientist, 40,000 people in California have been disenrolled. And I think there was a time, starting in the 90s, where the gaming money started coming in. There really was this huge uptick in that. And there are two things that have really pushed back on disenrollments, and I think it's really starting to decline precipitously. You're always going to have a little bit of that stuff, and it's not really justifiable, but the two critical things that have come back really are truly indigenous. One of them is just that tribes are establishing their own justice systems, right? And they're creating mechanisms that are beginning to, over time, become legitimate within the tribal community to address governmental abuses. And the fact that there are judges, that a lot of the disenrollments that got a lot of press in California and some places were by tribes that didn't have a court. There was no place to go to challenge that. Even if you were going to lose because the tribe asserted sovereign immunity, at least it would get in the public forum in some way. And I think the other response, and I'd like to think Angela has something to say about that, is there are a lot of outside international norms and also American norms. Winona wrote a paper on this as well, that are being injected into Indian country. And it's basically the way, if the United States operated properly, it's how they often reduce their human rights abuses. The international community started saying, you guys are being total assholes, stop it. And nobody wants to be that guy, right? So, and tribes are starting, that outside pressure, the United Nations Declaration, international human rights principles and policies are starting to invest and be invested in Indian country in a way. And I suspect, and I'm not an empiricist, so I don't know, that the disenrollment thing is going to sort of slowly take care of itself. And maybe it's because everybody's gotten disenrolled and there's nobody left, but I don't think that, I think it's starting to cure itself. I'd like to think that that's the case, but I don't know.
I mean, all I'll say to that, I don't know if it's getting better. I find it very troubling as well. I've seen comparable models outside of the U.S. Australia, for example, the government is very reluctant to recognize any kind of self-governance or sovereignty, but they've sort of, in their minds, kind of taken care of some of the problems that they created with the Aboriginal communities through payments for mining rights and other kinds of things, and it creates a very similar situation. And then outsiders look at it and say, this situation is totally dysfunctional. Certain people are holding on to the money and they're not engaging in good governance, right? And then there are other people who are being disenfranchised. And I feel like it's the same thing with disenrollment. That whole system, the whole idea of our blood quantum and our roles and all of that is not indigenous. That is from the top down. And it is an imperfectly imposed structure. And tribes are, I think, most of them acting in a way where they're trying to figure out how to operate within a pretty dysfunctional colonial system. I think it's the same thing with tribal criminal justice. As Professor Creel pointed out this morning, it's a system that gets put on top of you, destroys much of what makes you who you are, but then is so imperfectly and haphazardly imposed that you then have to figure out how to work within it to save it. And some tribes are doing better at that than others.
I just had a question for Professor Fletcher. Perhaps anybody there knows the dangers and answer. You mentioned the sort of concerted effort that your organizations have been doing with respect to ICWA. When I was a fairly new lawyer on the Hill, we ran into ICWA challenges because of the congresswoman, I think out of Ohio, who was adopting a native child.
Yep.
And so this has been around for a long, long time, challenges to ICWA. But I'm wondering, because I know that you mentioned some of the very intense efforts in terms of other organizations that are sort of trying to defeat ICWA and its purposes, that many of these cases, as you know, are very fact-specific. And of course, everything has to generate itself either in the state court system or at the very beginning in the federal court system. And so do you know of any sort of efforts to identify the types of cases that could develop into affirming law, or any organizations that are undertaking that effort? Because I think about the Nevada versus Hicks decision, for example. That passed a bad law.
Yeah.
And so many of these ICWA cases are very fact-specific, as was mentioned in terms of the opening line in the other decision, the other ICWA decision. So I'm just curious to know if you know of any of those types of efforts or experiments, I guess.
Absolutely. It's us at Michigan State. It's Kate Ford. She's sort of the center person. Anybody who has a complex ICWA case that goes up to the state appellate courts or somehow finds its way into federal court, somebody calls her, somebody calls us. And you know, we were working with the Tribal Supreme Court project on this, working with the national organizations as much as we can. A lot of the there's a group of tribes that are sort of the go-to tribes on this. In fact, they're the ones who intervened in the Texas case that really are providing a lot of the political and legal backing for really the defense of the Indian Child Welfare Act. We've been doing this now for really full-time for a good 5 years. And I want to be frank, and I don't want to insult anybody particularly, but I had said this before, Native American Rights Fund doesn't get paid when they win an ICWA case, and so they can't do a whole lot, but they've been really helpful to the extent that they can give us some attorney time. They've been great. NCAI has been a massive failure, and I mean that in the best possible way. I hope they improve it, but they have done jack shit on ICWA. And the sad thing is, there's meetings all day today. I'm getting, because of this case, it's coming down. And all we're getting from the leadership at NCAI is, thank God we're here, NCAI will save all of you, because we've been doing it all along. And we know that's not true. They don't help when it comes to the Indian Child Welfare Act. And I don't know why that is. I worry that, you know where the Indian Child Welfare Act came from was 20 years of Indian women complaining to tribal leaders who back in the 50s and 60s were almost exclusively men, to get them to do something about it. And it took decades for the Indian men in leadership to go to DC and start making that stand. And they finally did it. But that presumption, that bias against Indian women and children still exists. Too many tribes don't pay any attention to this until it's their case, until it's their kid, until they're the ones who are being vilified in the national media on YouTube or on Dr. Phil. Only then do they pay attention. It's practically already too late. I mean, we're already in Texas. You know, this is not something that, you know, is a new thing. This has been a concerted effort. The Goldwater Institute has been, and their allies have been consistently engaged in this for many years now. And they're extremely well organized and extremely well funded. And I pick on NCAI because they seem to be the national organization that claims to be the national organization that should be helping in organizing the response. It just hasn't been successful. And I don't know, right now that organization seems to be in shambles for other reasons too. But I do want to say one thing, and I think there's one thing up until this Texas case that I always thought in my mind, my cynical mind, was actually the saving grace of ICWA, is that they are all fact-based cases. That the worst case scenario is we get a really terrible case. A few years, like in the 90s, California appellate courts were striking portions of ICWA down left and right. And we were able, this is before my time really, but we were able to just sort of isolate those cases and kind of make them go away. We sacrificed those kids, though. We had to give up those children. The tribes and what would become the Tribal Supreme Court Project strategize of like the right fact patterns to bring to the appellate courts. We're still doing that quietly. We can't do it when it's the state of Texas bringing a full frontal challenge as a plaintiff to the statute. And this is why this is the one that everybody has to be galvanized about and to be organized. And, you know, I love what we do at Michigan State, but to some extent when it comes to complex federal appellate litigation and complex state appellate litigation, we are neophytes, we're law professors. But we are the ones making the choice. Really, it's Kate Fort on a day-to-day basis. Kate Fort is the only lawyer in the country who works 40 hours a week on Indian child welfare stuff in terms of this appellate litigation. She's the only one in the country. No firm dedicates anybody to it, no national organization. They can't for whatever reason. She is the only one. Several years ago, Kate and the rest of us at Michigan State organized something that for a while, we even got a logo and got some art for it. Like, it's called the ICWA Defense Project or something like that. And it had a whole bunch of attorneys affiliated with it. Some from NARF, some from NCAI, some from the tribes. And for various institutional reasons, they all had to drop out one after the other. And she is literally the only one left who works on this full time. And she's amazing. She's grown as a lawyer in a way that I never would have imagined when I first met her. But she's just one person. And she's not even native. We need more people. We need more help. I don't know if we're going to get it, to be frank.
We actually think that's time. I'm sure a lot of you have more questions, but we need to move on. So if you have one issue or request a question, I'm sure Leslie will be happy to talk to you about them during the break. You have 10 minutes. We're going to go back to the panel. Thank you.